right, good afternoon, everyone. We're on the record. This is Sherman. I like to refer to them as Sherman cases. State of Louis Sherman, deceased. Irene Sherman, deceased. Gerald Sherman, deceased. Arlene Sherman, deceased. Pierce, you're here on behalf of your law firm?
Correct, Your Honor.
So today's proceeding was the court's indication and notice the Sherrards that they have failed to respond to other notice. They've failed to account for the monies taken from the estate. They failed to pay their attorney fees. And they seem to have absconded. And this is set for removal today. So that's what we're here to discuss. How does Attorney Mills feel? How do you feel?
We agree with the court's motion, Your Honor, that I think what they've done well is a lot less than the things they've done wrong. So at this point, we would agree with the court's motion to remove them as fiduciaries.
Okay. So the court's inclined about their presence today. We tried to contact them in a variety of ways, researching our own on Facebook to identify them, calling houses where they've known, sending process servers. We have not been able to identify their presence either in Stark or Carroll counties, nor I don't know what work you've done, but I can't identify any assets remaining in Stark County.
Me neither.
Okay. So they will be removed. Now we have an estate without an administrator. So there's things, and you're owed attorney fees.
Correct.
So we can appoint an administrator to close the estate. That administrator could try and collect absconded assets and could collect on assets of the estate. The only one I know to be in Stark County is the judgment against Attorney Golub. We can have someone sue him to try and collect on that, pay the attorney fees of your firm. They could also go after the Sherrads. I mean, there's no priority under the law that says where you get your money. But without a bond, that's what you're left doing. So I don't know if your firm wants to be administrator and take on that burden, close the estate, sue to get recovery, or we appoint a third party, and we'd have to find someone who'd probably take it on contingency because they're not getting paid unless they get money out of Attorney Golub's judgment.
Your Honor, I think with the history that this court is aware of on this case, especially with Attorney Golub, I would request that a third party be appointed, not my office, just so there's no appearance of impropriety. As I think that there is a very vexatious litigant component to this, and so I'd rather have a third party be appointed.
Sure.
And we're happy to work with them and cooperate to the fullest, but I do believe that there are two avenues to try to recoup some of the assets, and that is through Attorney Golub and potentially through the Sherrards. But I think a third party is the safest thing for our office to do.
Okay, be fiduciary.
Correct.
But their compensation. Now, we could appoint a fiduciary who doesn't get paid, and they hire collection counsel, let's say, an attorney to try and recover these assets. And that person, that attorney, would have to, I assume, take it on a contingency because they may not get recovery. Or do you think that's the fiduciary? Let the fiduciary be the same person as the attorney who would probably have to take this on a contingency to go collect the assets?
I think having to be one and the same is a little more efficient. The question is, can we find somebody who's willing to take that risk? That is the inherent risk. But I normally would say my office would do it. However, I think as you're aware of the pretty lengthy litigation in this case, that anything that can cause rise to additional filings, some people are inclined to take it. So I'd like to avoid those.
Fair enough, and I understand. I mean, the easy thing today is we've removed the fiduciary. Done, over. I'm open to suggestions. I'll make a few calls, see if I can find anyone.
Okay.
Yes, Attorney Golub.
I would point out that under Rule 25, since the Sherrard, William Sherrard is no longer the executor, then Rule 25 comes into play, and all the claims of the fiduciary has against me goes away in accordance with Rule 25. So there is no judgment against me as of right now.
I would take that under advisement. I suppose that would be the next fiduciary's decision. They're just going to collect, and I'm sure they're going to try and collect against your judgment. It is the only local asset. But they can collect in any manner they see fit. Obviously, so the surety would collect it from the surety. You have something else to say, Attorney Golub?
Because there's a Court of Appeals case going, they have, their firm has not filed a response in that Court of Appeals case, but because that is going on, there has to be a fiduciary replaced quickly.
Again, I'll take it under advisement. I guess my question to you is, are you prepared to pay anything back? We could resolve this matter, I'm sure, if you simply paid their attorney fees.
No, I have to make it real clear. Rule 25, and there's some Supreme Court cases which say very clearly that I have no obligation whatsoever, and the executor has no judgment against me whatsoever.
Again, I'll take that under advisement. Is that a no? You're refusing to pay back the order of this court?
I think I'm going by the rule.
It's a yes or no question. There's been an order for years now that you're to return the money. Your answer to me is still today, after being found in contempt, your answer is still no. Is that correct?
That's correct.
You will not be paying back that money. We'll be hiring someone to get it from you if we can.
You know, real clear is that I have assets which are not attachable, and as such, the purge requirements in a case such as this goes by the wayside. And even you, in your approval of the 9C statement, said that my constitutional rights had been violated with the number of conversations that were going on, of which I had no knowledge. And under those two circumstances, among others.
All right. Again, I'll take your comments under advisement as we look at it, and I take it for the record, you still are in a position of refusing to honor this court's order and pay back that money. This concludes our hearing today. Thank you and have a great day. I finished the hearing. Thank you.
Thank you, Your Honor.